Um, okay, so hello everyone. This is a online discussion organized by a group of independent lawyers and network of judicial reformers, international network of judicial reformers. My name is Chyzhyk, and I represent a group of independent lawyers. The group of independent lawyers is not an NGO, it's just a unregistered union of approximately 20 people, judges, former judges, lawyers, former public defender, former chair of Bar Association, and so on and so on. We're plenty of experts in this group, and main purpose of the group is to contribute to the reform of Georgian judiciary. Basically, we are working on judicial reform. This is the primary target. So far, we have not touched any other area. Just not the prosecutor's office, not the bar or legal aid, nothing. Just working on the judicial reform. And I think this is going to stay the primary focus in the upcoming months or years. Now, just a couple of words about the network. The network of judicial reformers, international network of judicial reformers. Sorry, I think I'm going to turn off the sounds from everyone because there's an upcoming sound. Just a second. Okay, here we are. Okay. All right. So the network of judicial reformers, international network of judicial reformers, is a recently created network which has approximately 30 members and approximately from 30 members from 13 countries. This is a network of people who are interested to share experiences and knowledge about their judicial systems. We know that there's plenty of activities going on in many countries, like Ukraine, Kosovo, Poland, and Georgia and Armenia, and so on and so on. And we know, and the primary goal of the network is to exchange experience and to exchange knowledge about the situation in the judiciary, to exchange best practices, to talk about problems existing in these countries, because we know that problems are common. In many countries, we are facing common problems. And we want to know how you cope with these problems. Maybe we can benefit from each other. Maybe we can benefit from the innovations that you have. So today's meeting is exactly one of the primary activities of our network. It's a discussion on a particular problem of judicial reform. It's a problem of checking integrity of judges and members of High Council of Justice. Today, we are going to hear about Ukrainian experience. We will have a presentation from Halia, Chyzhyk, I'm not sure I'm pronouncing Chyzhyk, right? Yes, which is from Anticorruption Action Center from Ukraine. She's been working on the judicial reform, I think, for the last, I guess, 6 or 7 years, maybe. Right? Okay, so she's quite experienced and she knows quite well the situation in Ukraine, and she can. I'm sure that she will be able to answer all the questions that the participants will have. So the focus of today's discussion is the integrity of the judges and members of High Council of Justice. I am just going to say very briefly about the situation in Georgia. In Georgia, we have changed the legislative framework since the arrival of new government approximately 8 years ago. So we have introduced new regulations for the appointment of members of High Council of Justice. We have introduced more democratic rules of self-government, lifetime appointment of judges, including the judges of the Supreme Court. We have also made a lot of regulations in the judicial discipline, particularly when it comes to the investigation and prosecution of disciplinary offenses, also the new list of disciplinary offenses. We have introduced a new person, a specialized officer to investigate disciplinary offenses, which is the independent inspector. This independent inspector is elected by High Council of Justice. Basically, we have judges of Georgia have been appointed for 10 years, and many of them have expired. Almost absolute majority have expired their mandate in the last 9 or 10 years. So they had to be reappointed, and they were reappointed by High Council of Justice according to the new rules and procedures. But the problem is that we're not happy with these new appointments. They are appointed, majority of them are appointed for life. Some of them are appointed for probationary period of 3 years. And I think that the civil society and also the international, there's also international reports about Georgian judiciary. There's a lot of criticism of the appointment of judges in Georgia. Despite the fact that there has been plenty of regulations, a lot of transparency, despite of that, there has been a lot of criticism of the judicial appointments, particularly when it comes to the appointment of the Supreme Court judges. Very recently, there was an agreement between opposition and government in Georgia, which was called Charles Michel Agreement. It was mediated by the European Union, and the agreement was signed on April 19. And according to the agreement, the government was pledging a fundamental reform in the judiciary. However, recently, just about yesterday or day before yesterday, the government has unilaterally withdrew from the agreement. And there's a lot of international criticism because of that. However, the government said in Georgia that they will, however, execute the terms of the agreement, particularly reform. But the problem is that this judicial reform are less involvement from the civil society, and now there is a ongoing discussion among the civil society and the opposition parties to vet judges of Georgia, the judges who have been appointed for life, because they have not been appointed based on the merits. Or based on proper procedures. So there's a lot of discussion that we need to have some kind of vetting or lustration for Georgian judges, and we are looking to see, and we are looking for the experience of other countries who have done some kind of vetting, particularly from Eastern Europe. So this is why we have actively been proposing this topic on the agenda, and thanks to Halia, we are going to have a presentation on this topic today. We will hear about Ukrainian experience. How do we control and how do we monitor the integrity of judges and of members of High Council of Justice? So I now, by these words, if there are no technical questions or no questions about the format or agenda, I will deliver the floor to Halia, and she will introduce herself and she will do the presentation. And then we can start the questions and answers and discussion. Thank you in advance.
Thank you very much, Kaha. Good afternoon to everybody. It is a great pleasure to be with you today to share my knowledge and experience. It would also be great to meet offline sometime. I hope we will have this chance in the nearest future. So a couple of words about me. I represent one of Ukrainian NGOs, which advocates for anti-corruption and judicial reforms in Ukraine. For 4 years, I was a member of the Public Integrity Council. It is a civil society body that was created in Ukraine in 2016 to help judicial governance bodies with assessing judges and judicial candidates' integrity. Also, I was advising international experts who were involved in the process of selecting judges of the High Anti-Corruption Court. So I know a lot, and I'm here today to share my knowledge with you. So I suggest I will make my presentation, and then I will answer all the questions you have. So now I will share my screen. You see my screen? Yeah. Okay. So okay, let's go. So for the last 7 years, we had a lot of judicial reforms. After the revolution of 2013-14, like there was civil society's demand for justice. This was the main reason why thousands and millions of people came into streets during the revolution. So newly elected parliament and the president, they promised judicial reform to people, and they started with so-called illustration of judges. There was a law adopted that suggested the dismissal of judges who took arbitrary and illegal decisions against protesters. And this law also dismissed all members of High Council of Justice and High Qualification Commission of Judges. Unfortunately, this law did not deliver any results, as the procedures for the appointment of members of judicial governance, they was the same. It's just only people were changed, and these people were in charge of cleaning the judiciary from so-called Maidan judges who took decisions against protesters. And also this law envisioned that judges who have some properties that do not correspond to their income, these judges also had to be dismissed, but they were not. Then the next year, the parliament again tried to introduce some cosmetic changes. Again, it was called a new judicial reform, but no results were delivered. In the same law of 2015, it introduced the instrument of qualification assessment of judges. I will talk about it in details later. About what this procedure envisions. Importantly, the law did not suggest any effective measures with regards to those judges who have not passed this assessment successfully. This is why this public demand for justice again was not fulfilled. And this is why in 2016, Ukrainian authorities came up with comprehensive judicial reform. This is when the Public Integrity Council was established. This is when the idea of high anti-corruption court establishment was envisioned by law. This is when this huge reform of cassation courts in Ukraine was launched. But this reform failed. It failed because people who were in charge of the reform, these were the High Council of Justice and High Qualification Commission of Judges, they were not interested in delivering the same results as society was interested in. Because these were people who represented the same system that had to be cleaned and renewed. This is why civil society, we kept demanding the real judicial reform. And the window of opportunities opened in 2019 when a new president and new parliament were elected. And the first attempt of newly elected president, who was the author of the law that suggested the renewal of judicial governance, this first attempt was failed again because High Council of Justice, which was in charge of implementing the law, it sabotaged the implementation of the law. And afterwards, Constitutional Court of Ukraine also ruled on unconstitutionality of some very important provisions of this law. And it took us 2 years to advocate for the relaunch of this reform, of the effective reform. And finally, we succeeded. And 2 weeks ago, the Parliament of Ukraine finally adopted 2 very important laws, which suggest completely new procedures for for selecting members of judicial governance. So we have 2 very important topics here: the integrity of judges and integrity of the members of judicial governance. And I would like to start with the latter, because Ukrainian experience proved that you cannot ensure that judges meet integrity criteria unless you ensure that those who assess judges, those people who will be in charge of vetting judges, unless you ensure that these specific people themselves meet integrity criteria, you can try anything you want. You can adopt any laws, but at the end of the day, the result will be the same. We had a lot of failed reforms, and now we believe that we received a real chance for the actual reform, because this time we are starting from the most important, from the integrity of members of judicial governance. So we have 3 bodies in judicial governance in Ukraine. The most powerful is HCJ, the High Council of Justice. It makes the most important decisions on appointments, dismissals, and disciplinary sanctions. With regards to the appointments, decrees on appointing judges assigned by the president, but president's functions here are ceremonial, and president cannot refuse to appoint a judge recommended by the High Council of Justice. And according to the Constitution, president has only 30 days to appoint a judge recommended by the HCJ. High Council of Justice since 2016 solely decides on dismissals. Before 2016, this decision was made by the president and the parliament, because before 2016 we also had this system of first 5 years appointment of judges, and then judges were appointed for lifetime. In 2016, since 2016, all judges are appointed for lifetime, so we do not have this period when judges are checked and then they are appointed for life. High Qualification Commission of Judges. It is an independent body, and it conducts selection of judges. And after this process ended, HQCJ submits recommendations to the High Council of Justice. And also High Qualification Commission of Judges conducts the evaluation of current existing working judges. And we also have Council of Judges. It is a self-governance body responsible for conducting the Congress of Judges, where members of judicial governance are appointed. And frankly speaking, Council of Judges has no real powers, but I'm only mentioning it here because it will play some role in the reform. So according to the Constitution of Ukraine, High Council of Justice consists of 21 members with the majority of judges, because there are 10 judges elected by their peers and a head of Supreme Court, who is a member of the council ex officio. And we also have 2 attorneys elected by Congress of Attorneys, 2 prosecutors elected by Congress of Prosecutors, 2 law professors elected by Congress of Law Universities, and
Parliament and President each appoint 2 members of the HCJ. HQCJ is not mentioned by the constitution, so like it is only envisioned by laws of Ukraine, and initially members of the HQCJ were like selected the same way, but since 2019 the members of the HQCJ are elected at an open competition. It's just we, for these 2 years, we did not have a chance like to try this procedure, to implement new procedure for the appointment of HQCJ members, because High Council of Justice sabotaged the implementation of the law. And this is why for almost 2 years, we do not have any HQCJ operational. With regards to the reform of the High Council of Justice, the law that was voted by the Parliament of Ukraine 2 weeks ago envisions the establishment of a special body, which is called Essex Council. Essex Council consists of 6 members. 3 are judges or retired judges nominated by Council of Judges, the body that I mentioned before, and 3 international experts nominated by international and foreign organizations which cooperate with Ukraine under international treaties in rule of law and corruption counteraction. Importantly, the law does not say that these 3 international experts should be foreigners. The law only suggests that these 3 persons should have foreign experience, at least 10 years experience in prosecuting corruption or considering corruption cases as a judge. The law suggests that the term of Essex Council is 6 years, and then the members of the Essex Council should be re-elected, and international experts are the part of Essex Council is only for 6 years. After 6 years, they will be replaced by members appointed by attorneys, prosecutors, and law universities. So we can say that it is extraordinary measure, temporary measure, aimed at ensuring integrity of judicial governance with involvement of independent international experts. The authority of the Essex Council is to assess candidates to the High Council of Justice, whether or not they comply, whether or not they meet integrity criteria. Meaning that it doesn't matter who is the appointing authority, but the law envisions that the appointing authorities should consider only those candidates who successfully passed evaluation conducted by the Essex Council. The law envisions that Essex Council should submit at least 2 candidates for each vacant position in the High Council of Justice. But importantly, appointing authorities like Congress of Judges, the President or the Parliament, they cannot appoint those candidates who was not green-lighted by the Essex Council. Importantly, Essex Council also should conduct a one-time integrity screening of current members of the High Council of Justice, and in case Essex Council will decide that some members do not meet integrity criteria, it will initiate the dismissal of such a member, but the final decisions will be taken by those authorities who appointed this member. Initially, we advocated for a different model because, given these appointing bodies are those who appointed these tainted people in the first place, we do not trust them. We do not believe that they will dismiss those
those tainted people. But there were a lot of speculations with regards to the constitutionality of this Essex Council authority to dismiss. However, Constitution is silent with regards to the dismissals of members of the HCJ, meaning that like the procedure should be set up by law. But like at the same time, we failed with advocating for strongest model here, the model that would allow us to dismiss current members of the High Council of Justice upon the decisions of the Essex panel. But at the same time, we succeeded with advocating for some provisions that make dismissals more effective, and I will mention about it a little bit later. With regards to the reform of the High Qualification Commission of Judges, which will be launched which was voted by the parliament the same day and will be launched soon. The law suggests the establishment of competition commission, which main task is to conduct selection of members of the HQCJ. Like the composition of this body is the same: 3 judges or retired judges and 3 international experts. There's only one difference, as the law does not require members of competition commission, I mean international members, to have these 10 years of experience. The law only says that this should be highly reputable experts. So the authority of competition commission is like to Competition Commission is fully in charge of the competition. It announces the competition and importantly decides on the rules of the competition, because the law that was adopted 2 years ago and that was never implemented, it suggested that rules of procedure should be adopted by the High Council of Justice, and HCJ used this authority to sabotage the process. So now it is the Competition Commission who will decide on the rules of the competition. Competition Commission should assess whether candidates meet the integrity and professional competence criteria, conduct interviews with the best candidates, and then submit the list of 32 preselected candidates for the consideration of the High Council of Justice. Again, here the final decision of appointment of members of the HQCJ will be made by the HCJ, which will receive the list of 32 and will have to select 16 candidates. The most important elements of both laws, which allow us to say that this will be a real reform, is that international experts in both panels, in Essex Council and Competition Commission, will have a decisive role. Because both laws envision that the decisions should be deemed taken as if they are supported by a majority of votes, including at least 2 votes of international experts. But in case there is impossible to reach an agreement and to get the majority of votes, like 4 out of 6 votes, in case of a tie, the vote supported by at least 2 international experts prevails. This was the hardest thing to advocate for. Judiciary and members of parliament, everyone in Ukraine who represents authorities, opposed this approach, why it is so important to have this decisive role of international experts, and importantly in case of a tie, is that if we only have this rule that decisions are taken by the majority of votes, this means that when we have 3 judges in the panel, that means that if all 3 do not support the decision, in particular, if all 3 do not support a decent candidate, then this candidate cannot go through, he should be disqualified. So at the end of the day, we could receive a situation when international experts ban all bad candidates, judicial members of the panel ban all the good candidates, and then we compose the body with so-called
gray horses, like with candidates whom we do not know anything good or bad, and we do not know what should we expect. But the goal of this reform is to ensure that the best and the best people are appointed, people who have reputation in the society, who have some experience, who are independent and honest. And because we will entrust these people with vetting of judges. So this is why we find this rule for the tie vote crucially important and like the most important part of the laws. And the second crucial element, which might not seem so important in the first place, is the establishment of reasonable doubt standard of proof. Both laws suggest that because in both laws there should be members of HQCJ or HQCJ selected, and they should be assessed whether they meet integrity criteria. So when the decisions in this regard is taken, then like this standard of proof is used. And the law clearly says that candidate is considered as not meeting integrity criteria if there are facts proving that he does not meet integrity criteria, or if there is a reasonable doubt of whether he meets integrity criteria. Because like it will be very hard, and within this competition proceedings, we might be never able to prove that candidate did something wrong. That's like he violated the law or rules of ethics. So what we need to prove is only that there is a doubt of whether like a candidate's behavior was perfect or not, and that is a game changer, I would say. So, with regards to reform of judicial governance, like also very important moment, I already like mentioned this with regards to the cleaning of the High Council of Justice of current members. As I've said, we did not succeed in advocating for the Ethics Council dismissing members of the HCJ. But we advocated for very important provisions that help us to make these decisions more effective. So the law suggests that in case Ethics Council recommends to dismiss tainted member of the HCJ, the appointing authority should conduct 2 votings. This, of course, refers to Congresses and the Parliament, and it does not refer to the President. So there should be 2 votings. First, voting in support of the recommendation of the Ethics Council. Members of the Congress, for instance, Congress of Judges, should gain the majority of votes in support of the recommendation. We assume that there will be no majority of votes in support of the recommendation. But this will not mean that if they do not gain the majority of votes, then the member of the HCJ keeps his office, because they should conduct a second voting to overrule the recommendation of the Ethics Council, and here they should also gain the majority of votes. We think that it might be harder for judges or attorneys to gain the majority of votes against the recommendation of the Ethics Council, and this is why we believe that it makes this option of dismissing HCJ members more real. And the law also envisions that if any of the decisions taken within 3 months, the HCJ member is dismissed. So like the situation when appointing authorities delay with taking the decision, or they postpone their meetings all the time, this situation will also lead to the dismissal, so they will not be interested in delaying with this. And also important is that according to the law, once Ethics Council decides that member of the HCJ does not meet integrity criteria, he is suspended from office unless appointed authority, until appointed authority makes the decision
upon the recommendation of the Essex Council. So now I will move to the integrity of judges. The process that was launched, vetting of judges, was launched in Ukraine a few years ago. However, this process was not successful. So the law of 2015 and then 2016 envisioned qualification evaluation or qualification assessment of judges. High Qualification Commission of Judges is in charge of this process. This is extraordinary procedure. It applies only to existing judges or judges who apply for positions in appellate courts, higher courts, like High Anticorruption Court or High Intellectual Property Court. We have only 2 higher courts in Ukraine, and cassation courts, like courts within the Supreme Court. So we do not have regular qualification assessment of judges. The aim with regards to the existing judges, this is one-time extraordinary procedure aimed at checking whether they are competent enough to consider cases and whether they meet integrity criteria. The law adopted in 2016 and constitutional amendments envisioned that those judges who will not successfully pass the qualification assessment have to be dismissed. So the law was good because it envisioned the dismissal of judges who will fail integrity assessment. But the implementation of law was not good at all. So a little bit more about the procedure itself. Qualification assessment of judges envisions 2 stages. At first stage, the knowledge of judges is checked. They have to pass testings, this is testing of their knowledge of Ukrainian laws only, and practical assignment when they judges. It's like an exam. Judges receive some task, and upon this task, they should write a judicial decision. And the second stage of this process is integrity and professional ethics assessment. Within this stage, interviews are conducted by the HQCJ, interviews as a final stage. Before the interviews, members of the HQCJ analyze candidates' dossiers, meaning that they just collect and analyze all the information that relates to the integrity of professional ethics. And here where Public Integrity Council participates by also assessing judges' integrity and providing its opinion of non-compliance with the integrity criteria. I also forgot to mention in my presentation, there is a very important element of integrity and professional ethics assessment. Candidates also there's psychological testing of judges. In 2016, an independent psychological company was involved with the money of our Western partners. Special psychological tests for judges were presented. And according to the regulations of the HQCJ, judges or candidates for judicial positions, they should pass these psychological testings, and they should also have interviews with psychologists, and psychologists prepare some reports. And members of the HQCJ receive results of these reports, but psychologists, they do not give their marks to judges interviewed. They only write some notes. And the results of this psychological testing, and upon the results of this testing and upon the reports of psychologists, members of the HQCJ decide on whether or not judges meet integrity criteria, and they also assign some scores to judges based on the results of the testing. There were a lot of scandals with regards to this psychological testing. First of all, it turned out that the company that was in charge of drafting this, like preparing these tests, it combined different testological techniques for assessing different like skills, mental skills of judges. And one of the tests they applied was the test that actually is used by the office of this company in Bulgaria. But there it is used to check the people who apply for jobs in supermarkets. And this test is designed in a way to check loyalty of people, because if you own a shop, like it is important for you to know that person you hire will not steal, that it is completely loyal to you. And this test was like taken to test Ukrainian judges, and it was designed in a way to assign higher scores to loyal judges and not independent ones. And this is what was one of the problems with the appointment of judges of the Supreme Court in 2016, because independent judges did not receive high scores for integrity assessment, and those who previously were known for taking politically motivated decisions, for keeping silence and tolerating illegal practices in courts, they were like received very high scores. So if you will have some questions with regards to psychological testings, I will address them later. Now a few words about the Public Integrity Council. Like it is a 100% civil society body incorporated in judicial system. It consists of 20 members delegated by NGOs dealing with rule of law reforms, rule of law and human rights reforms. Members of the Public Integrity Council are not appointed by judiciary, by parliament, or the president. According to the law, NGOs who meet the requirements set up by law, they suggest the people to the Public Integrity Council, and then they conduct a joint meeting of representatives of these NGOs who conduct voting, and upon the results of these votings, like those people who receive the most votes, they are appointed members of the Public Integrity Council. High Qualification Commission of Judges here plays like some organizing role. It announces the process of selecting members of the PIC. It receives documents submitted by NGOs, and it conducts this like meeting of representatives of the NGOs who will participate in the actual elections. The authority of the Public Integrity Council is to assess judges, current judges within this extraordinary procedure for qualification assessment, and to assess whether they comply with integrity and professional ethics criteria. And also the Public Integrity Council assesses judicial candidates, those who apply for appellate courts and cassation courts. Because first instance court judges, they do not undergo qualification assessment. So there is some different procedure for selecting judges. It is not ideal because integrity of judicial candidates is not assessed within that procedure. So I think this is something we will focus on when we finish with judicial governance reform. We will try to amend the legislation like to ensure that all those who apply for first instance courts, that they also undergo integrity assessment. And in case Public Integrity Council decides that a judge or judicial candidate does not comply with integrity criteria, it sends a written negative opinion to the High Qualification Commission of Judges, and also participate in the interview with the judge and have an opportunity to ask questions with regards to the opinion of the PIC. Importantly, the law gives very small powers to the PIC. According to the law, if there is a negative opinion of the PIC, then HQCJ should meet in plenary and it should vote in favor of a judge by at least 11 votes. If less than 11 votes, if there are less than 11 votes, then judge is considered as the one who did not pass qualification assessment and he has to be dismissed. Or if we're talking about the candidate, then candidate cannot participate in the competition anymore. When this law, when this provision was incorporated in law in 2016, we were very happy because we considered it as a real power, as a real way to influence the results of evaluation of judges or selection of judges of the Supreme Court, because we thought that 11 votes out of 16 are enough, and we could not imagine that members of the HQCJ will vote in support of tainted judges after the Public Integrity Council will bring them proofs and facts of dishonest behavior. But we were wrong, and members of the HQCJ easily overruled the opinions of the Public Integrity Council, even despite all the interviews were broadcasted online, and they are still available on YouTube. Despite the negative opinions of the PIC were published online, so everyone could understand what is wrong with a specific candidate or judge. This did not prevent HQCJ members from voting in support of bad judges and bad candidates. So here are the results of civil society involvement in judicial reform. Within the Supreme Court competition, the majority of opinions of the PIC were overruled by HQCJ, and now there are 55 judges out of 200 who do not meet integrity criteria according to the PIC, who were actually appointed to the Supreme Court. So each fourth judge of the Supreme Court is dishonest, and I mean that there are obvious discrepancy between lifestyle and official declared income, or there is a lot of dishonest, a lot of politically motivated arbitrary decisions taken by these judges before. And facts of that kind, when it is obvious for everyone who look at these facts that this guy should not be even a judge of a first instance court. I'm not talking about the Supreme Court, but despite that, HQCJ in 2017, 2018 recommended these tainted judges to the Supreme Court, and then High Council of Justice supported these recommendations. With regards to qualification evaluation of existing judges, before the authority of former composition of the HQCJ was terminated in 2019, nearly 3,000 judges out of 5,000 passed the evaluation, and only 77 did not pass it successfully. But only 1 out of 77 was dismissed due to non-compliance with the integrity criteria, meaning the rest 76, they did not pass the first stage where their knowledge was assessed, they did not pass tests and this practical assignment exam. So this number, only 1 judge was considered as non-compliant with integrity criteria by the HQCJ and HCJ, it talks by itself. Public Integrity Council provided hundreds of opinions concerning these judges, but almost all the opinions were ignored by the HQCJ, and in those cases where HQCJ agreed with the peak, High Council of Justice stepped in and said that no, we will not dismiss this judge. And a lot of judges, this is why only one judge was dismissed at the end of the day. So the Public Integrity Council was established in 2016. It participated in the Supreme Court competition of 2017. Then the procedure for qualification evaluation of judges was launched. And you see the results, the peak was not effective at all, but the reason for this was not the members of the peak, but the main reason was that members of the HQCJ and HCJ, they did not took the opinions of the peak. This is why when
Halia, sorry, can I just very short remark? And I'm sure very much other participants are also the same, would have the same question. Was it possible? Did you discuss the possibility to make the opinions of integrity checks mandatory, entirely blocking the candidate without any further procedure?
Meaning that civil society decides and judicial governance does not decide at all?
Yeah, just blocking the candidates without overruling, without the possibility of overruling the assessment of these integrity councils.
It would be great, but it was impossible to advocate for. So it is a matter of political will. There was no political will in 2016 to give real powers to the civil society. And we clearly see that there's no such a political will right now. And it is easier for some reason, it is easier for our authorities to involve international experts, but not to involve civil society. There is a huge risk, that you need to be very careful when you engage civil society and when you authorize civil society with this kind of powers, because there is a huge risk that civil society experts, civil society organizations, will be captured by bad people. So there should be some safeguards in the law with regards to the criteria for NGOs who can nominate their members and criteria for the people who can apply. When Ukrainian legislation with regards to peak was adopted, it envisioned very good safeguards. Only those organizations who have at least 2 years of experience in implementing international technical assistance project and who has successful results of financial audit could apply. Meaning that some pocket NGOs, which actually belongs to some politicians, MPs or judges, they could not nominate their members to the peak because they don't have this experience in implementing some international technical assistance. They do not have this successful experience of cooperating with some international organizations upon these international technical assistance programs. So this was a safeguard, but you should be very careful when you involve civil society, but we have great experts here, and we think that it is better to have civil society in the reform of judicial governance, because we are more experienced, we know the context, but at the same time there are some pros for involving the international experts, and this is where I will tell you about the Public Council of International Experts, a special body that was established for the selection of judges of The Hague. Why special body, like we had the peak already, why this body was established. A real reason was that HKCJ ignored the Public Integrity Council, and it was clear that if we have the same procedures for selecting judges of the Hague, the result will be the same. Dishonest, loyal, politically controlled people will be appointed, so there is no need to establish specialized court to consider high-profile corruption cases. Civil society suggests to involve international experts, and IMF supported this idea. So this was the involvement of international experts were the part of, it was a Ukrainian commitment before IMF. And international experts were involved because the Public Integrity Council was not powerful enough. Of course, another option would be to give more powers to the Public Integrity Council, but as I already said, there was no political will for that. And international partners of Ukraine also supported more involvement of international experts rather than involvement like civil society. They did not want to I don't know how to say that. They did not want to take the responsibility for civil society in that process. So this special body was established only for the purposes of selecting judges of the High Anti-Corruption Court. So this was like one-time task. According to the law, 6 experts, this body consists of 6 experts nominated by international organizations cooperating with Ukraine in the field of counteraction corruption under international treaties of Ukraine. According to the law, international partners suggested the list of 12 prominent experts, and HKCJ selected 6 experts. The difference between the PCIe and the PIC is that the PCIe had a veto right. In case the Public Council of International Experts decides the candidate does not meet integrity criteria, then a so-called special joint meeting of PCIe and HKCJ is conducted, and there was a special requirement with regards to the voting on candidates. So there were 22 people voting, deciding whether to support the candidate, questionable candidate or not. And it does not matter how 16 members of HKCJ vote, but in any case, 3 members of the PCIe should vote in support of the candidate, meaning that if 4 out of 6, at least 4 out of 6 do not support candidate, then he does not go through. And the procedure was extremely successful. With this voting requirement, Public Council of International Experts succeeding in banning 85% of questionable candidates within the competition. So there were 2 or 3 judges who somehow managed to gain support of international experts, and they were finally appointed to the High Anti-Corruption Court. But at the same time, it's not like what we have with the Supreme Court, where each 4th judge is a notorious one. We do not have the same picture with the High Anti-Corruption Court, and this court has been operating for more than nearly 2 years, and it already demonstrated different quality, and it already brought to real criminal responsibility with real imprisonment of judges who took bribes, for instance. So these are the results of the PCIe involvement, and now this is the end of my presentation, and I just want to show you the small part of the interview with a judge within high anti-corruption court establishment. So now you see there are 6 members of the Public Council of International Experts. They will conduct an interview with a judge whose integrity was questioned by the PCIe. What you don't see at the screen right now are members of HQCJ. They are sitting in front of the PCIe, so they are all present there. So I will not provide you with a lot of details regarding this case, because this is not the matter here. It's just I want to show you how international experts played their role in interviewing tainted judges. There was a problem, so what was the problem with the integrity of this judge who applied for the High Anti-Corruption Court? She took within pre-trial investigation, she granted to NABU detectives access to bank accounts of some companies that were investigated. But later she changed her decision by narrowing her order, and she called it as a correction of typos. So she probably took a corrupt decision and called it correction of typos. So now I will turn on the video. This will be only 2 minutes, and I hope that you will enjoy it.
And please ask the question again. It's so simple. You made a ruling in December. There was a detective present, and you made an order.
Yes.
That order was taken, we now know, to the bank.
This ruling was provided to the detective for ensuring its execution.
The ruling was taken to the bank. We don't need to go into everything, who's had breakfast. It's taken to the bank.
The court does not refer it to the bank, and it provides it to the detective who came to court.
Give it to the detective takes it to the bank, and he says, this is the order of the court. That's what happens in every country in the world.
In Ukraine, it happens as follows. After hearing the detective who comes to court with specific motion agreed by the prosecutor, there is a consideration of this motion. During such consideration, a participant of the hearing may be either a detective or a prosecutor. Then, upon the results of such consideration...
Sorry, this is a point of order. This is such a simple question. You give it to the detective takes it to the bank. We know that happened, because that's why the bank wrote. So why can't we just say yes? We don't need the whole code of criminal procedure of Ukraine to say yes.
I'm sorry, but I've understood that you're asking about my actions. Yes, the detective sent this ruling to the bank, obvious.
And when the bank then makes a statement on the 23rd of January, of which we have 1 page only, and in effect they're asking for the order to be narrowed, to be made thinner, to be made less wide, whatever language you want. Yes or no?
In fact, yes.
And then you did what the bank wanted.
The matter is that the party who comes to court, this is just the first ground for taking materials of the case and to study them.
Bank, you did what the bank wanted. Yes or no?
No.
Did you narrow the order? We've already accepted you narrowed the order. You narrowed the order because the bank asked you to.
If the question to me is set as to a lawyer, then I have to answer it with legal language. In the understanding of the Criminal Procedure Code, I'm convinced that in this particular case, I corrected the spelling mistake, since the essence of the decision
clearly hopeless. I'm just giving up my questions. I think I've made the point.
So this example, this only one small example from the whole procedure with the appointment of judges of the High Anti-Corruption Court. This judge tried to avoid answering the question because, like, it was obvious that she changed her decision in favor of this company that was investigated by detectives. And this is how, like, reasonable doubt standard of proof works. So it's just only members, international experts just showed that there is a reasonable doubt with regards to candidates' compliance with the integrity criteria. This is the end of my presentation. So now I will be happy to answer your questions, because I guess that there are you have a lot of questions, and I did not address a lot in my presentation. I guess I forgot to tell a lot of important stuff. So now please ask me. And how to stop sharing my screen?
Okay, it's like I think maybe.
Yes.
Oh yes, that's done. Okay, thank you. So thank you very much for this excellent presentation. This now time, it's time for questions and discussions, and I will, as a moderator, I will start my first points. I will use that possibility and ask a couple of questions. The first question is about the decisions of the judge made in the past. And we have judges in Ukraine and in Georgia who have made thousands of decisions in the past. Some of these decisions may be of poor quality, and some of them may have a tainted decision, as you say, that some of their decisions may be tainted character. We also have judges who have been appointed based on informal negotiation with some appointing body, maybe with a member of High Council of Justice, and if you appoint me, and I will do something for you, and things like that. We may also have some facts of the nepotism inside judiciary. For example, we recently have a case in Georgia. We recently had a case where a member of High Council of Justice has promoted his son to be appointed as a judge. So a guy who became a member of High Council of Justice in 2017, his son was very quickly accepted as a candidate as a student in High School of Justice. Then his son graduated the High School of Justice, was appointed as a judge very quickly and very easily. And we suspect that there was a protectionism, there was a chronism, or what you call a special treatment. We also have cases, we may also have cases of promotions based on some kind of loyalty, based on some kind of a secret deal between the appointing body. So how do can we identify, could you identify those cases in Ukraine where the judges have not been appointed properly or with inappropriate secret negotiations or something? This is one question. A second question would be about the property and tax declarations, the property declarations. Usually, when you follow the property declarations of the judge, in Georgia at least, you don't see a very much discrepancy. Judges had, well, a judge who was working in Georgia for 10 years, the judge is getting approximately from $500,000 to 18,000 Georgian lari, because the judicial salary, we have a decent salary in judiciary, and so the judge is accumulating approximately $500,000 during this work. So if the judge has bought a property of value 200,000 value, then how can you say that his income is not in compliance with the property? It's difficult to say. Otherwise, then you should follow his factual property, identify the property of his grandmother, the property of his cousin, the property of his brother and sister, and things like that. And how, well, maybe some judges, maybe they have their property who is registered to the relatives, on behalf of their relatives. So how can you identify those cases? And also the third question would be about the qualification. You said that approximately 70 judges have been disqualified because of the integrity criteria, but you didn't say that they were disqualified because of the competence criteria. And so maybe I have missed this part. How many judges have been disqualified, at least by the council and by the commission, because of the integrity criteria. So these are my first three questions, and maybe we can follow question and answer basis, because yeah.
Okay, so I will start with the last question. It is the opposite. So only one judge was dismissed due to non-compliance with integrity criteria, while 76, they did not pass like knowledge testings.
Okay.
Out of 3,000 assessed, and it cannot be true, because I mean that we have people do not trust judges. Judges took arbitrary, corrupt decisions all the time. So numbers with regards to the integrity assessment should be much higher. And in case only one judge out of 3,000 does not meet integrity criteria, that means that we have a perfect judicial system if all the judges meet the integrity criteria. With regards to decisions of judges, it is the hardest to prove that judge does not meet integrity criteria, referring to decisions he taken. What I did not tell you is that despite the law says that judges should undergo integrity assessment, the law does not define what integrity is. It does not define the set of like criteria, set of indicators judges should be checked whether they comply with these indicators or not. And the problem is that High Qualification Commission of Judges, which was in charge of this process, it failed to provide this kind of methodology. They made some poor attempts, but to set up this, to list the criteria, but there were only a few criteria. They again said that judge should meet professional ethics criteria, referring to the Code of Professional Ethics. And with regards to integrity, yes, the methodology of the HKCJ is published on their website. And with regards to the integrity criteria, HKCJ set few indicators with regards to discrepancy or correspondence of lifestyle and official income. And there was nothing there. But we cannot say that integrity is only about lifestyle and properties. So the Public Integrity Council decided to rely on Bangalore Principles of Judicial Conduct, because it is an international document. It was drafted by judges from all over the world. And after a few years of our work, day-to-day work on assessing judges' integrity, we came up with our own methodology. I will share this document with you. And I know that I promised to do this before, but I was looking for updated version. So now I have it. I will share it with you. So PIC came up with very detailed methodology based on our own practice, where we found judges we assessed or judicial candidates as those who do not meet integrity criteria. We tried to agree with HKCJ on joint methodology, but they refused to, because they do not want to have this detailed methodology, because it will be harder for them to explain why they green light tainted judges with having clear criteria in methodology. And like these judges fail to meet these criteria, but at the same time, HKCJ greenlight them. So again, coming back to the decisions, it is very hard for outside observers to say that there is something wrong with the decision, because we do not have case materials, and there is this like international standard that judges should not be punished for their decisions unless like there are some corrupt decisions, or like there is a list of criteria for that. And it was very hard to discuss these matters with members of the HKCJ, because they like each time the peak tried to say that this judge does not meet integrity criteria because he took bad decisions. Each time HKCJ referred to like this standard, saying that we will not go to assessing decisions because there is a procedure for assessing judicial decision. It is appeals and cassations, and another way is the decision of High Council of Justice, which decide on disciplinary measures. So what was our solution? If there are some facts, or at least reasonable doubt of whether there was some interference, like political interference or something like that, then we said that like there are doubts of whether this judge is independent when this decision was taken. For example, like one of the famous cases in Ukraine is when during ex-president Yanukovych times, like leaders of opposition were imprisoned. These are like leader of opposition party Yulia Tymoshenko, and also her colleague Yuri Lutsenko, who during Poroshenko's time was prosecutor general. So judges who took decisions against, so there were judges who took decisions against these political figures. They imprisoned them, and there was the decision of European Court of Human Rights. There was like resolutions of European Parliament that it was political persecution. So these judges applied for positions in Supreme Court. So we referred to these decisions, and we explained that this is a violation, with like citing positions of European Parliament, European Court of Human Rights. Like we relied here on well-known, well-reputable institutions. At the same time, like of course, we do not have these institutions commenting on all the cases. So there is a third principle in Bangalore principle saying that like it is not enough to administer justice, but it should be obvious for the society that justice is administered. So we, in case where there are some arbitrarily motivated or questionable decisions of judges, we try to explain, to use this in our argumentation. We refer to this principle, we refer to the articles in media, like showing that like there was very important for the society cases. Like sometimes there are a lot of protests there, like there are a lot of people who decide, maybe there are experts organizations who comment on these kind of decisions. So we always try to show that like the problem, we cannot say that this decision is illegal, but we say that it was not obvious for the society that justice was administered here. And with regards to properties, it is very important to mention that since 2016, all declarations submitted by public officials, including judges, are available online. Judges annually declare their income and income of their families. They should also declare savings in cash or money on bank accounts. They should also declare their real estate. They should declare like cars they have, and they also should declare some valuable properties like furs or jewelry, or for example, like one of the members of the HQCJ even like indicated in her asset declaration kitchen stuff because it was so valuable. It was more than 5,000, like $5,000 or $10,000. This is why she declared even like her kitchen stuff. All this Chanel, Louis Vuitton bags, like this all have to be declared. So this system is very like transparent. So it makes easier for us as a civil society to conduct this property check. And it is also important that judges were not highly paid till 2016. So yes, it is much harder for us to prove that they acquired some properties using illegal sources since 2016. Now they have like huge salaries, and now it's almost impossible even to say something about Supreme Court judges because each earn $10,000 a month, and for Ukraine these are huge amounts. But at the same time, like Public Integrity Council found a lot of cases of undeclared properties or properties that were registered on family members, those who are not indicated in property declarations. So yes, we are not always able to find these facts, even if there are something, but at the same time, there are a lot of cases, and like there are a lot of journalistic investigations with regards to the lifestyle of judges. And sometimes even months ago, my colleagues from another NGO, they published this like shocking information about deputy head of the Supreme Court. Like he earns a lot, like monthly, he earns more than $10,000 for the last 4 years. So it is hard to say that when he buys something that he does not have enough money, but somehow he managed to invest in like extremely expensive apartments in the center of Kyiv. So he cannot explain, like, so if we compare the cost of these apartments, the price of these apartments, and his numbers from his declaration, we see like obvious discrepancy. So somehow even cases of that kind occur, but of course like it does not happen so often. But at the same time, like this financial money criteria, it is easier to prove, like it is easier to vet judges referring to lifestyle, income, money, than referring to like decisions he took. And there is a very common practice in Ukraine of judges being drunk driving. And we have a lot of cases, when police catch judges drunk. So we also refer to this as a violation of, at least violation of ethics. And with regards, like I mentioned one case with regards to the judicial decisions. According to, to Code of Administrative Proceedings of Ukraine, there is like if a person was caught by police drunk driving, there is only 3 months to bring this person to responsibility, to administrative responsibility. And there is like a huge corruption practice in Ukraine when judges delay with taking decisions within 3 months. So as a Public Integrity Council, we like, I don't know, it's like one of my colleagues was checking one of the judges, and like he decided to check these like specific cases. So like after this like case, we decided to implement like this in our practice. So now we check all the judges whether they took this kind of decisions. So there might be these different cases where we can, and there are judges in Ukraine who like took hundreds of decisions of this kind, like when they delay with considering these cases. And these cases are very important because like we're talking about people's lives. So it is one of the way to show like problems here, to to prove there is a problem here, to show that, like, for example, this judge considered 200 cases of this kind, and in 190 cases he'd failed with taking a decision within a time period of time. Yeah, so I guess
let me jump in just one more, and I've just finished. Did you have cases of ex parte communication? Because in Georgia, we may have a lot of cases of ex parte communication with the judges, but they may happen inside judiciary, like court presidents talking to the judges on giving specific instructions on specific cases. And did you have those cases disclosed by Integrity Council? Ever any of those cases disclosed by Integrity Council? Ex parte communications on specific cases.
I don't remember. If there were some cases, there were maybe 1 or 2 cases, but I don't remember. We made some opinions saying that judges do not seem independent and unbiased. We have a lot of cases where, but it is about Ukrainian context. We have war in the East, and there are a lot of judges who work very close to the zones occupied by the Russian Federation. So sometimes these judges consider from time to time they have to consider cases involving our enemies, bringing them to criminal responsibility. And unfortunately, we have a lot of cases when judges refuse to consider this kind of cases because they have property on those occupied territories, and we consider it is one of the criteria of the PIC. We say that these judges are not independent. We have a lot of judges who illegally cross these so-called borders with these so-called republics. And we also say that these judges are not independent because they put under threat their authority to administer justice, and they can be blackmailed. They can rule in favor of our enemies. But it is about Ukrainian context, and we have a lot of decisions on opinions on non-compliance with independence criteria, on promotions, for example. We have some cases when there are some judges who had friends or relatives in judicial governance, and we explained that they were promoted. For example, there was a judge who became a Supreme Court judge within 5 years from being appointed the first instance court judge. And his mother-in-law was a member of the HKCJ at the time he was appointed to the Supreme Court. So he was appointed first instance court judge, and within 5 years, a person made this terrific career in judiciary, even passing this stage of appellate court. So we have cases of this kind, but the Public Integrity Council also is not able to prove everything. We cannot say that the member of the HKCJ influenced her colleagues and this happened, that she promoted her son-in-law. But what we can say is that we can show this very strange, weird career promotion, which is not likely for Ukraine, for other judges who does not have relatives. And we show that there is a proved fact that there is a relative, so there is a reasonable doubt, and the judge should provide his explanations, at least how maybe he was very smart, maybe he was very talented, and this is why he was promoted.
Okay, thank you very much. I think I took a lot of your time. Now, dear participants, please, you're welcome to ask questions to Halia. you can raise your hand just or speak directly, because we have freedom to freedom of discussion. Okay, Bessarion Alavidze from the former justice from the Supreme Court. Bessarion, you can ask in Georgian if you want, and I can translate for you. Or you can ask in English, in both ways, whichever.
Thank you, Halia. Thank you for interesting speech. There was many new points for me, and as Kaha mentioned, in Georgia court system we have lots of problems. We have a kind of problem like not transparency. High Council of Justice refuses all conclusions or suggestions from non-government organization and from international experts. And I'm interested how is political willingness in Ukraine, and how do judges refuses court reforms or new amendments or new points in court systems.
I guess this is, I guess the question is about whether judges are resisting to the reforms generally, right? Sorry, the judges are resisting to the reform proposals generally.
Yes, it is a great question. Like, unfortunately, we, as I mentioned, we have 5,000 judges, but like it will take me only like my 2 arms with my 10 fingers to list independent judges. So yes, unfortunately, we have the same problems as you do. We have clans control judiciary, and judges they not only resist these changes and reform, they actively oppose the reform. As I said, High Council of Justice used its authorities to sabotage the implementation of the reform 2 years ago. So we have to come up with new legislation depriving HCJ these powers and ensuring that this time the reform will be implemented even the HCJ is not happy with this. Judiciary uses its influences and the biggest problem we face right now is the Constitutional Court. There is the majority in the Constitutional Court are former judges. They have very close links with the judiciary, and they also have corruption issues themselves. So the Constitutional Court right now, with some exceptions, is a part of the same corrupt judiciary. And now Constitutional Court is very powerful because now it can rule on unconstitutionality of the reform I described to you. So it is a huge threat, and unfortunately Ukrainian authorities have not addressed this problem. We've been talking about the reform of the Constitutional Court for years. This problem was prioritized in October last year when Constitutional Court destroyed electronic declaration system. And then the president started talking about the need to do something with the Constitutional Court. The solution is here again to provide competitive selection of judges and integrity checks of future members of the Constitutional Court, but the relevant legislation still has not been introduced. So this is a threat. And now, after High Council of Justice tried to they negotiated with the members of parliament, and they had a lot of support within the parliament. This is why it was so hard for us to advocate. After the law were adopted, High Council of Justice published statement against the reform, and 2 days ago 4 judicial associations which unite few hundred judges published a very like emotional and pathetic statement against the reform. So judges do not support this reform. There are only few judges who are not afraid to talk publicly about the problems of the judiciary and who publicly support the reform. And the first question was about the recipe of our success. So first of all, we have a strong and active civil society in Ukraine, pushing the government, the authorities to launch and implement the reforms. We also, like as a civil society, we are also experienced with our previous failures, because in 2016 we believed that now we will implement a genuine reform. We believed, we took an active part, and everything failed. So we have this knowledge, experience, and another successful recipe is that involvement of international community. European Union and IMF made judicial reform as conditions for providing financial support to Ukraine. According to Ukrainian agreement with IMF, Ukraine cannot receive a loan of $1.2 billion until it adopts the law on the HCJ reform. And memorandum with IMF was very specific. So it did not say that there should be the reform of judiciary or the reform of the High Council of Justice. Memorandum specifically suggested that there should be special body established with at least of half of members with international experience, who will conduct pre-selection of future members of HCJ and who will be able to conduct one-time extraordinary screening of members of the HCJ. So the memorandum was very specific, and it was hard for authorities to avoid this reform, because they need money. The same is with European Union. Ukraine signed agreement with the EU last year, and it also repeated commitments regarding HCJ, and it also involved commitments with regards to the HQCJ. So I would say, and besides that, so it's it is easier when you commit to these reforms before international partners. So there is a pressure on the authorities. They need money, and if they want to receive this money, they should have deliver results. Also, we cooperate, as a civil society, we actively communicate with G7 embassies in Ukraine. And frankly speaking, it works like sandwich. So there is Ukrainian authorities in the middle, and we have civil society pushing hard for the reforms on one hand, and international partners also waiting for the reforms. They mention all the time that there should be the reform. So Ukrainian authorities, they do not have a lot of area to avoid these reforms. So I would say that the hardest in this advocacy campaign was to convince Venice Commission members that this is important, not only to have international experts in the process, but to give them a crucial role in the process. And Venice Commission members, when they assessed draft law on HQCJ and draft law on HCJ, they met with not only with the parliament, with judiciary, but they also met with experts from the civil society. We were able to raise our concerns. We also provided them with our analytical papers in written. So we provided them with a lot of arguments why it is so important to have these extraordinary measures to involve international experts. Why this is so important to ensure that these international experts will have a crucial role. And now I believe that after Venice Commission supported this for Ukraine, it will be much easier for Georgia, for Moldova, for Armenia to like advocate for this kind of measures, as like Council of Europe and Venice Commission in particular supports this approach, supports the involvement of outside experts.
Okay, thank you. Thank you very much. I think I would just want to mention one example before we move to the next question. I can mention one example from Georgia, which will be maybe interesting for you. Actually, recently, there were 6 new Supreme Court judges appointed by the parliament, and there were public interviews. They were boycotted by part of the opposition and part of the civil society, but some opposition and some civil society attended the interview, and I was personally there, and I also asked some questions to the candidates. And one of the candidates was a president of court for a long time, just about approximately 10 years ago, and he was a president approximately for 5 years. And when he was the president of the court, he actually was pressuring a judge to take specific decisions. And this judge, who later appeared at the interview in the High Council of Justice, he accused the court president. He said, "You were pressuring me to take particular decisions, but we had a fight. We were fighting about it. We had struggles and fights about it." And that's what the judge accused, a former judge accusing court president. Actually, this was disclosed to the Parliament Committee, and it was disclosed, but they did not react about it. You know, they just completely ignored it. And I was the only person who asked this question to the judge, and he did not answer my question. Then this candidate was approved, and he became a member of the Supreme Court. This clearly shows that our parliament is absolutely not a filter to vet unworthy or unethical judicial candidates who have done something wrong in the past. So our parliament is absolutely not a filter to do any kind of integrity check on the candidate. So we probably, the Georgia does need some kind of integrity filter, but this is something which is under discussion right now. So, okay, I will stop here and I will move to the next question. Please, Irakli.
I have a question to Halia regarding Ukraine. I'm interested about your personal opinion. How long it will take to reform Ukrainian judiciary? I know there are many variables and many presumptions should be in this answer. But I've heard that for Georgia, I heard from foreign colleagues. I don't like to say international expert because no international experts exists. There are some German, United States, and people who have different backgrounds, maybe more than one country. But it's always interesting local context, because local context is always different. We could have some same problems. We have different context often. So I've heard that it will take, with vetting, it will take less time. Without vetting, it can take more. For my colleagues, I've heard about 5 years, about 10 years regarding Georgia to get we cannot get ideal system, and we could not get full independence. Nowhere it's not possible in this world, but I'm talking about sufficient required degree of independence and competence. So what is your perception if things will go in the right direction politically in Ukraine? There will be no war with Russia, no additional occupation, thanks to God. And how long it will take?
Well, a year ago, I met with some experts from Expert Center from UK, and they told me that according to some research conducted by Oxford professors, it takes at least 20 years to introduce systemic changes in rapidly developing countries, not like Ukraine, Georgia, or others. So for our countries, it is even more. But we don't have this many years. So like we cannot waste our time. We have a lot of like challenges. As you mentioned, this is war. It is strategic threats to democracy, and like with regards to the reforms I was talking about, judicial governance bodies reforms, law is very clear here. So we expect a judicial governance bodies, HKCJ and ACJ, to be cleaned within a year once both panels are established. If Essex panel will succeed with vetting all members of the HCJ, then it within a year we can receive renewed body. More pessimistic scenario is that it will take 3 years to completely renew the High Council of Justice, because we will have to wait when their authority expires. They are appointed for 4 years. So yes, it is from 1 to 3 years for the complete reboot of judicial governance, and then these bodies have to clean and renew the rest of judiciary. Yes, and this will take some time. I guess additional 3 or 5 years to appoint new judges and to dismiss those who do not meet integrity criterion. But I believe that once judicial governance is rebooted, and once this body start delivering results, when they will dismiss at least 5 judges who violated rules of ethics, who took arbitrary decisions, this will be very clear signal to the rest of the system that look, judges, if you will do the same, if you keep these illegal practices, then you will be dismissed. So I believe that this will have a disciplining effect on judiciary. So I'm very, frankly speaking, I'm very optimistic here. It's just the most important and difficult task right now is to ensure proper implementation of this judicial governance reform, as adoption of the laws was only the first step and it was not the hardest one. Now we need to find great experts who will commit themselves to spend some amount of time doing this very important job, assessing candidates for HCJ and HKCJ. We have to ensure that both panels will receive, they will be informed. They will have all the information about the candidates, so they will be able to effectively conduct their duties, and they will be able to vet the candidates and select the best candidates. So, yes.
Let me just jump in very quickly. Do lawyers come up with some specific facts about judges in your country? This is something which, before I forget it, do lawyers, you probably have a lot of thousands of lawyers in Ukraine. Do they come up with specific facts about candidates?
Our bar association is also not good, as this attorneys are those who give bribes to judges.
Okay.
So we have but at the same time, but not all attorneys are corrupt and bad. When the public integrity, when I was a member of Public Integrity Council, we have a lot of letters from lawyers. They were complaining on judges, but it was very hard to check because like they were referring to some violations of the legislation in specific cases, and like we did not want to dig into these details because we will never be able to prove that the judge was wrong when he considered this case. But at the same time, sometimes lawyers provided us with information of like this the judges were biased, they were influenced somehow, they were not independent. So in some rare cases, this information was valuable for us. And yes, there are lawyers ready to like provide information about judges. But at the same time, sometimes they just want to use this vetting procedure to get rid of judges they don't like. It does not mean that these judges are bad.
Okay. Okay, thank you. Maya?
I see some questions in the chat, so I need
Yes, there are questions in the
to
chat.
actually-
Before we move to Maya, you can read these questions in the chat.
Well, with regards to time limits, there was so the law envisioned in 2016. The law envisioned that all the judges should undergo qualification assessment. There are like integrity and professional skills have to be checked, and those who fail, they should be dismissed. The law did not set the deadline. It was hard to set the deadline because like there were 5,000 judges, and at the same time, the Supreme Court selection was a priority. So there was no deadline, and but HQCJ was interested in finishing this process as soon as possible. They like wanted to conduct the assessment of 5,000 judges within 3 months, and this was impossible. Like the first day interviews lasted for 3 minutes. So it was like judge comes, like he asked his name, where he works, and okay, goodbye, you passed the assessment. And like Public Integrity Council was like so disappointed. Then like we did not see how we can contribute to the results of the process. This is why we even withdrew from the process. We made a press conference saying that this is not a proper assessment, like when integrity interviews last only 3 minutes, and like there are a lot of questions to this judge, but HQCJ members do not ask them. This is not okay. Judges cannot be green-lighted this easily. So then we tried to postpone the process, to delay the process. Judges tried to refer, HQCJ and judges referred all the time to the recommendations of the Council of Europe, which say that there should be, the law should set up the deadlines, and these check-in procedures should not last forever, because it is the way to control a judge, and it harms his integrity. So this is why HQCJ explained why they trying to conduct the procedures as soon as possible. But again, the answer to this question is that Ukrainian legislation did not set the deadline, and I think that we need to have some reasonable amount of time to conduct this assessment. Of course, this should not be 8 or 10 years, but this also should not be a few months. It depends on how many judges are there. It depends on on how busy is the body who is in charge of the process. And the most important is to assess all the information carefully. With regards to the...
Sorry. Excuse me, thank you for the whole information and for the answer. But I mean the analysis of dossier, for example, dating 2010, going back, can they go back and analyze the information of existing judges?
With regards to the integrity, yes, there are no limitations in the legislation. So I mean that if, for example, in 2010, a judge was caught drunk driving, we can refer to this fact as that he does not comply with integrity criteria. With regards to the qualification assessment of judges, the law was silent in this regard. But importantly, these laws on HCJ and HKCJ reform that were adopted by Ukrainian parliament 2 weeks ago, they contain special clause in this regard, envisioning that there should be no limits, like time limits or area limits with regards to the integrity assessment. This is something that HKCJ tried to do with the peak. Like they tried to say that we cannot assess the facts that happened like 2 years ago, or they said that if, for example, some public authority decided that there are no problems with assets declaration of a judge, then Public Integrity Council cannot say that there is a problem, even if we show that, like, look, here are facts proving that guy lives in this house and this house is not declared. Or, for example, there are information in state registry that this house belongs to judge's wife and he does not declare this house. But HKCJ said, like, he passed assessment conducted by fiscal service or some other body, and they said that everything is fine, so you cannot again take this as an argument. So
Thank you. Thank you.
Okay.
Thanks for that.
with regards to the parliament, like this was a huge problem because there are no rules for the parliament. Parliament has to appoint two members of HCJ, but there is no procedure for assessing the integrity of candidates who apply. And this, of course, this assessment is very formal and politically motivated. So this is why we have completely new procedures. So Essex Council will assess all the candidates who apply, green light best candidates, and the parliament will be able to appoint those who successfully pass the assessment conducted by the Essex Council. The same with Constitutional Court judges. Parliament appoints 1/3 of judges of the Constitutional Court without checking whether they comply with the criteria. Like there was very there was a ridiculous case. A guy, according to the Constitution of Ukraine, a person should have at least 15 years of legal experience to be appointed a judge of the Constitutional Court. And in last year, a guy applied, he was a current MP. He was nominated by pro-Russian political party. He received his bachelor's degree in law in 2013, meaning that in 2020, he had only 7 years of legal experience. And this guy was green-lighted by the committee, parliamentary committee that was in charge, and his candidacy was voted by the MPs. He did not gain the majority of votes, but committee decided that he complies with the criteria, and it is obvious. We do not talk about integrity or reputation. It is very obvious. He has only 7 years of experience instead of 15, but he was green lighted. So we have huge problems with that, and now we are trying to fix this to involve independent body assessing candidates who will be appointed to the Constitutional Court.
Okay, thank you very much, Halia. Now we have Maya, the next, and then will be Tamar.
Thank you, Halia, first of all, for being with us your Friday evening, and thanks to everyone to join the discussion. I have a couple of questions concerning the integrity check, personally about the ethic councils, and also the PIC. If their opinions are negative, and we know that the High Qualification Commission and High Council of Justice has power to overcome the negative opinions of evaluators. And what will happen next? Will the judges, will some kind of procedure, disciplinary procedure begin with this? With regard the judge who was assessed as a non-integral integrity whose integrity was assessed as negative, or it stops here. And what about the member of the candidate of the High Council of Justice? I have the same question. Should he or she continue their work as a judge with this kind of background? And if you remember, my second question concerns about the reports and the evaluations of the ongoing reforms in Ukraine. You remember we have talked about it a couple of months ago, and you promised me to send some materials if it will exist in future, because somehow we together didn't find some kind of evaluations of these reforms. Are there any news in this direction? And the third question, it's a very simple question. Who evaluates the evaluators? I mean the members of the PIC or Council, Ethics Council or PCIE. Are there any mechanism of their liability? Maybe they will be not, maybe they will, their behavior will not be so transparent, or maybe there will be some misconduct in their behavior. I don't know. Is there a mechanism in future to evaluate these persons? Thank you once again.
I will start with the third question. The law does not provide for any liability mechanisms or for checking the evaluators. Maybe this might seem a problem, but the whole idea of involving civil society and international experts is that we involve independent and honest people here. So it's we involve well-reputable people, and it is the same with the civil society. Civil society, people who are appointed to the Public Integrity Council, they should meet the requirements set up by law. Maybe there is a gap in the law, but I can, and of course I'm biased here because I was, for 4 years, I was a member of the Public Integrity Council, but I can tell you that there were 2 convocations of the PIC which served 2 years each. And there were 30 people appointed because there were 10 people who participated in both convocations. So overall 30 people appointed. And for 4 years, there were 0 scandals involving these people because these are my colleagues are the best representatives of the civil society. They have their reputation. And in fact, our reputation is all it is everything we have. So and the law did not require us to be transparent or open. We did it ourselves. We created without any sources, we created a website where we published all our opinions. However, the law did not require us to publish our opinions. We broadcasted online via Facebook, because we did not have any other resources. We broadcasted our meetings. We invited people, everyone who was willing to participate in our meetings, he could attend. And we suffered from that because there were some crazy people coming, trying, they have some personal problems with judges and they wanted to use PIC as a revenge. So they took hours of our time explaining their cases, but at the same time we did not close our meetings. We were open, and we also decided that we will submit assets declarations. However, the law did not require us to do this. So, but yes, it depends on who is appointed, and there is a risk that not like good people might be appointed, or they might be good at the moment of the appointment, but then something happens, they might be been bribed, and there are no mechanisms. So maybe there is a need to envision this kind of mechanisms for national experts, but I don't think that like we should do this with international experts, because like we mean that we involve the best people who are known like all over the world for what they do. So like we just assume that they are great, and we do not include any like safeguards. With regards to the reports, evaluation reports, since the law was only adopted, it has not been implemented yet. So like there are no reports. There are only like explaining materials of what these laws envision. We have a lot of reports on failures of the reforms, previous reforms of 2017, 18, and I guess I shared these materials with you already. It is very important to pay attention to who is the author of the report, because like our problem in Ukraine was that even like international partners, somehow they involved some biased experts who provided like whose task was to prepare the reports on the reform, and there are a few reports which say that Supreme Court competition was very successful, that there were no problems with that process, and there are reports criticizing the Public Integrity Council instead of High Qualification Commission of Judges. I do not say that PIC did not make any mistakes. We made a lot of mistakes, like because we did it for the first time, like we did not have any secretariat, any support. We did not have a lot of time, but we were not in charge of qualification assessment. Our task was only to provide opinions, and the body in charge of the process and responsible for the results was the HQCJ. And you also asked what happens with judges. Nothing. For example, if in case the PIC says that this judge does not meet integrity criteria and HQCJ does not agree, overrules the opinion, that means that judge keeps his office. The same with the candidate. If HQCJ overrules the opinion, then candidate is recommended for the appointment. If, for example, there is a candidate who is existing judge and he applies for a job in Supreme Court or some higher court, and he, like there were some cases when when HQCJ agreed with the PIC and disqualified like that dishonest candidates who are working judges. So they just turned back to work, and of course, like it is logical that HQCJ should initiate the dismissal of these judges, because if they do not meet the integrity to be like judge of the Supreme Court, this means that like they are not good enough to be the first instance court, because there cannot be different kinds of integrity for different like courts. And the same was with the competition for the High Anti-Corruption Court. There were like 32 judges who were vetted by international experts, but they were not dismissed. They are still they keep their position. They are still judges. So like, yeah, this is the problem. I don't think that we have to address this problem by amending the legislation, but I think that this is the task now of rebooted judicial governance. Like High Council of Justice has this instrument of disciplinary proceedings, and HQCJ still has to assess, evaluate 2,000 of judges who has not passed the evaluation yet. So like they have to take into account all these facts. So we believe that if we ensure that people like professionals who meet integrity criteria will be appointed, then they will like take care of this.
I think I will. Thank you very much, Halia. I think I will give the floor to Tamar. But before she asks the question, just as a general comment, that we as countries, transitional democracy, countries of the transitional democracy, Ukraine and maybe many others, they by this vetting, which is of course a very necessary procedure in Ukraine, we are wasting our resources. I mean, we have been wasting our resources in the past. This means that we have been wasting our resources in the past while appointing those judges. You see, because ideally, you should screen the judge for qualification and for integrity during appointment. When the judge is appointed, then he should be screened entirely with his qualifications, skill, the background, career, misconduct, decisions, whatever, anything about the candidate. Then once you're appointing the candidate, then you are sure and you are confident that he's a good judge, right? So the vetting is, can we say that the vetting is a delayed examination of a judge, but necessary? It's a delayed process. It's a late process, but it's better late than never. Can we say that it's better late than never about this process?
Of course, and I just completely agree. I just want to add that it may also happen that the candidate is perfect. There are no problems. But after the appointment, like something happens and like he's right. So like you cannot be sure that if you appoint a good guy, that he will be perfect forever. So this is why like it is okay to vet judges. And in particular in these extraordinary situations with judiciary, we have like, we share the same problems. Our judges are not independent. So they were never properly vetted. This is why we need to do this now.
Exactly. Thank you. Please, Tamar, it's your time.
Thank you very much. Thank you for a very interesting presentation. I have a question about vetting procedure. As you know, that the aim of vetting procedure is to check the acting judges and also to prove also the candidates for these positions. But my question is about the acting judges. The aim of vetting is dismiss the corrupt judges and to prevent the society to have judges who are influenced by the majority party or political wills of the executive and to have an independent judiciary. You told us that the big problems are about this, like in Georgia, that the judiciary is not independent. But my question is, which results had a vetting? Can you assess and tell us that the vetting was positive? Vetting had a positive results about it, or I think you presented that only one acting judge was dismissed, and there is questions about a lot of judges that they are corrupt and they obey the maybe I don't know to whom, when Parliament passed a new law about the vetting and they want to make the situation better, and Parliament wants to have an independent judiciary. To whom are based today these judges, and what do you think the vetting law in the Ukraine had a good results till today, or it's only normal or only formal? and only on the paper to show that the new government wants or new parliament wants to change something, and happens in the reality nothing. And these judges who are corrupt, who obey the government and etc., they keep these positions and they can continue to do what they want again, and to stay in the same situation. And what I want, another question is that the sanctions, which kind of sanctions can make the commission? They can dismiss the judges from these offices, and are there another sanctions also about this? Can they press and influence the judges to retire? And also the burden of proof. Who investigates all these cases? Who can prove that the judges are corrupt? How the evidence can be collected about this? And is this the situation that to provide this evidence to these judges and tell them, now you had to retire, or we can go publicly, and then it brings not so good, or they can say, we dismiss you because we have evidence. And the dismissed judges, has he applied, went he to the appeal court and appealed these decisions?
Okay, thank you, Tamar. And very good questions. And I will add one more thing. Halia, you said the judges are not independent in Ukraine. And the question is, if they are not independent, what do they depend on? You know, what is the basic source of dependence? To whom they depend if they are not independent? What is the basic cause of dependence? You know, that's also I would add to the Tamara's question. Thank you.
I only want to add. Halia, you promised to send some methodology. If the answer of this question exists in the methodology, we don't want to waste your time now with regard to the particular part of this question. And Tamar has joined late, a bit later, I think. So I also had this question, but I think after getting the methodology, some kind of answers on this question will be clear. Isn't it right, Halia?
Yeah, but like there are a lot of documents, so it it will be easier for you to listen to me now. So I will start.
Thank you.
I will start with the vetting of judges. It failed, like Ukraine failed with this because it was conducted by unvetted judicial governance. Like unvetted HKCJ and HCJ were in charge of the process. This is why we have this result with like almost all judges successfully passing integrity assessment. There's no political will, like Ukrainian parliament and the presidential office, they do not want to vet judges, but like the parliament adopted like judicial governance reform because of the pressure of international partners and civil society. But even if there was a political will, I doubt that we can like introduce re-vetting of judges, because like Venice Commission, Council of Europe will oppose this, because like we introduced vetting a few years ago. It was like explained as extraordinary procedure. Judges passed this procedure, so it will be very hard for us to explain why we need to do this. So I don't believe that this is possible, and I believe that the real way here is to like to deal with bad judges in terms of disciplinary proceedings. Like this is why we need like a renewed High Council of Justice. And this is why I would recommend you to start with like ensuring the integrity of those who will decide, like who will be in charge of the vetting, and only afterwards to initiate this vetting. Because like we have like very good legislation, but it was implemented by very bad people. So with regards to sanctions, like within this procedure of qualification evaluation, this extraordinary procedure conducted by HKCJ, there could be only two options. Either judge successfully passes this or he fails. In case he fails, he has to be dismissed. HKCJ recommends the dismissal and HCJ decides, like dismisses. The problem is like the law does not oblige HCJ to dismiss. And like we have a lot of cases when HCJ, without providing substantial arguments, like decided not to dismiss. Even HKCJ recommended dismissal, saying that judge did not pass qualification evaluation. So within disciplinary proceedings, there are different sanctions. Judges can be fined, like they can be withdrawn from office. Sometimes, like it is very funny, but sometimes when like HCJ says that judge violated professional ethics, or High Council of Justice sends him for like study in School of Judges. So like I don't think that it is like a proper like relevant punishment here in these cases, but we have this kind of sanction. So this can be fines, temporary withdrawal from office, suspension from office, and like the hardest measure is of course the dismissal. There was a question who investigates. Like within qualification assessment, this is HKCJ and also the Public Integrity Council. HKCJ also receives analytical reports from National Anticorruption Bureau of Ukraine. It is law enforcement institution that investigates top corruption in Ukraine. But they also like prepare these analytical reports, and like as a peak we also had access to these reports. NABU does not conduct like this declarations checks. They only collect information from state registries and put all this information in their report. So it is much easier for the peak like to conduct the assessment. We always pay attention, like they NABU give information about like foreign travels of judges, so we can see what is the lifestyle of a judge and his family members. We have a lot of judges who travel a lot, who spend like 1/3 of a year abroad. So we can say that oh, it is not okay. And we also used this information and compared this data with data from registry of court decisions. And we found a lot of cases when like judge took decisions where actually he was abroad. So like proving that like he somehow violated the legislation by issuing decisions when he was abroad, because of course he did not. And probably the reason like there's these problems with data is because like he failed to deliver a decision in a reasonable period of time. We have like judges are investigated within criminal proceedings by National Anticorruption Bureau. They can also be investigated by State Bureau of Investigation if this is not a case of corruption, but some like other kind of crimes. But like if we're talking about qualification evaluation, it is the HKCJ. And we have also National Agency for Corruption Prevention, which task is to assess all the declarations submitted by public officials. So, for example, this institution can also provide its opinion if it conducted a declaration check of a judge. and this information should be taken into account. But in this case, this institution is able to initiate, like it submits documents and High Council of Justice opens disciplinary proceeding, and a judge can be dismissed for this reason. And there was a question whether judges can appeal the decision. Yes, they can appeal the decisions of HKCJ and HCJ to the Supreme Court. So according to our legislation, Supreme Court is the first instance court for appeals on the decisions of judicial governance bodies. Did I miss some?
My question was about what the judges are dependent on. You know, why, you know, what's the primary source of dependence? To whom they depend, to whom they depend.
It is a huge question. First of all, heads of courts.
Okay.
And second of all, when it comes to judicial, appointments to judicial governance bodies, when Congress of Judges decides, then judicial clans are trying to influence judicial selection. So we have a lot of cases, and there are some people represented clans. They travel all over Ukraine, convincing those judges who will participate in the Congress to vote in support some specific candidates. And judges are also politically dependent. Of course, not all the judges. So some judges have connections with some politicians, like oligarchs, MPs, presidential office, and some of them are influenced by High Council of Justice. So, for example, if someone wants to, for example, if presidential office, like it happened a few years ago all the time, presidential administration did not call all the judges to say what they have to do. But if there was some important process and they wanted to influence a judge who will consider very important for authorities case, then they used High Council of Justice to influence this judge. For example, a lot of judges who took decisions against protesters during the revolution, they were kept in office, and it turned out that these judges later considered political cases. So they were influenced by the High Council of Justice, which used the instrument of disciplinary proceedings. And the same with all other judges, instrument of disciplinary proceedings is used to deal with independent judges. They are punished. And those who act upon instructions, they are not punished, even if they have to be punished.
Mm-hmm. I see. Actually, I would add on the Georgian context that the Georgian Dream, which is a government party, which is a government party, their official position was stated in multiple declarations of the leading politicians from the government party. And the official position about judiciary is that the judges, they have been doing bad things in the past. Before 2012, there were millions of bad cases. The judges were fulfilling instructions from the executive, from the Minister of Justice. But after 2012, they are doing good things. So the official governmental position is that we did have bad judges from 2012, lots of bad judges, but they became good judges after 2012. So if we approach to the government saying that we want to vet judges for everything that they've done in the past, they will say, wait a minute, we have pardoned everything that happened, amnestied everything that happened before 2012. So you cannot go back to cases of 2010 or 11 or 7 or 9, because we know that they were doing bad things before 2012, but after they are doing good things. So that's the official position from the government of Georgia. I mean, because there was voiced many, many times by the official channels, you know.
Sorry, Kaha, may I interrupt? But now they serve the new government, the Georgian Dream. It's a main issue. They serve today the Georgian dream like they serve the former government.
Yes, yeah, Tamar is right. And but basically, the attitude is inside the official attitude inside judiciary and outside judiciary, the governmental position is the complete irresponsibility of the judge. You know, every judge is, no judge is responsible for nothing. You know, it doesn't matter. You take a decision, you have taken a decision which was criticized by the European Court. It's okay, don't worry about it. You have been biased in the past, no problem, you know, don't worry, we'll keep you. You have been pressuring other judges, no problem, you know, you're pardoned, you're excused. So, you know, every judge in Georgia basically has been excused, and officially or unofficially. So basic policy is the complete impunity. And that's the official attitude. You know, we keep the judges impune and they are going to become independent. You know, they are irresponsible, but they will be independent by this irresponsibility or immunity. I think that's the main attitude, you know, of the judicial administration and of the Georgian dream. Yeah, that's like a comment. This was like a comment I wanted to make, you know. Okay, if we are approximately, we have been sitting and talking approximately for 2 hours and 43 minutes. So it's a long time. I think we have had a lot of questions and a lot of answers from Ukrainian experience. And if you have participants, dear participants, thank you for everybody's patience and thank you for your interest. And if you have last remaining questions, please go ahead and then we will sum up.
Only one gratitude to Halia, because she somehow make a lot for today's evening, the Friday evenings. It was spent, she spent it with us, and she gave very useful information. Thank you, Halia, for your beautiful presentation. I hope that you will send it to us, isn't it so? The video is mainly interesting for me. I want to watch it one another, and I also want to watch the whole version of these discussions if it's available publicly.
Yes, yeah. Today's discussion, you mean, Maya?
No, I mean the video, the discussion between the panel and the judges, Halia Joe, the video,
I see.
her
Right.
presentation.
Yes. And can we see more about these videos like it? Can we see it in YouTube or somewhere?
Yes, I will share with you the link to YouTube channel. It is an official channel of HKCJ. It is in Ukrainian, but like you will not have troubles with finding these interviews. You just have to like scroll, because like it happened 2 years ago and they have a lot of videos uploaded, but I will like send you a few links. Thank you very much. This was my pleasure. I will share with you, of course, I will share with you the presentation and the materials. I mentioned criteria of the peak, methodology of HKCJ. I also will try to find our legislation translated into English. If you will have any follow-up questions, please message me. I'm always in touch, and I will be happy to provide you with more details. And I would be very happy for you if you succeed with adopting similar legislation in Georgia.
Thank you very much.
Okay, thank you to Halia. Thank you, everyone. Girakli wants to say something, please.
Yeah,
just
close up comments. I see that Halia is very optimistic and it's a very important precondition to succeed, because without such optimism, there's no chance to succeed. And if you believe, that's what was I taught by my American colleagues, that in order to win the case, you should believe that you're in the case, that your client is right. That's what we defense attorneys are doing on daily basis. So we also need, it means that we need in Georgia a group of people very optimistic about such success. If we'll have this sufficient number of professionals, like Halia is in Ukraine, we succeed as well. So it's my